guys out and getting signed up and floating in, but to maintain on schedule, let us get started. Welcome to the Robert Jackson's semi-annual CLE, and we're thrilled here. We're going to be talking about a variety of subjects, but the foremost one will be the reflections on the Voting Rights Act of 1965. A little housekeeping matters. One, the emergency exits are here. Hopefully there will be nobody who will want to exit through those. Also, for the lawyers, make sure you fill out these two sheets when you leave, or those credits, which include an ethics credit, will be unavailable. And I'd also like to just state that we last night had a wonderful event here at the Robert Jackson Center. We premiered the movie Liberty Under Law, the Robert H. Jackson story, and that will be available because several people have asked, and we decided to do that, make the tape available. So throughout the event, if you want to purchase it, for what we're still giving out, Jim, we're still going to give them the still benefit of last night. Man, that does nothing for our bottom line, so you still get the break. And also, I want to introduce just some new folks who are at the Jackson Center. You, of course, know Liz and Jim, but also Marion Beckerink, who is our Director of Development. Marion, if you want to raise your hand there, welcome. And also Tom Schmidt. Tom Schmidt is now our Executive Director at the Jackson Center. We welcome Tom, and everybody knows him in that fashion. So welcome to our new staff. This event does not happen without the support and sponsorship of a whole lot of folks, and they are on this list here. But let me just call them out because some of them are here. And American Digital Services, Brad Walters. Brad is right back here. Very relevant, not to give it a long plug, but very relevant to what Craig's going to be talking about here in just a few minutes. The American Digital Services project, which is terrific. Thanks, Brad. Cattaraugus County Bar Association, the Chautauqua Sports Hall of Fame, which will be providing pictures to be autographed for Larry Playfair, who will be our guest speaker during the lunch hour. And also, if anybody wants to take on Larry, there is a bucket. Just put your name in. Somebody will be selected, so we'll have a little bit of a tussle with Larry Playfair later on. Anybody here? Steve, you want a piece of that action? Okay. DFT Communications Corp, 5-star. By the way, as I mentioned these corporations, raise your hand so everybody knows who you are. 5-Star Bank, Steve. Forcon, the Greater Chautauqua Region Estate Planning Council, which many of them are here. Heritage Ministries, Doug. Holt Associates, there she is, for there, thank you so much. Jamestown Bar Association, many here. The Jamestown Jammers Baseball, the two Tonys are here. And we have the manager and the general manager, and soon we'll be listening to a lawyer from the Milwaukee-based organization, which will be talking about the legal aspects of sports marketing. Fascinating guy, and also a former scout with the Milwaukee Brewers. And his name was up next to Craig Counsell's, by the way, to being the next manager of the Brewers. He didn't get the call last night, did he? I didn't think so. Jamestown McAdam, Kessel Construction, Key Bank. Where are my Key Bank folks? There we are. Where's the rest of you guys? Don't you let them? Perfect. Cheap seats. The Northern Chautauqua Bar Association, several of them are here. Peak and Peak Resort, Kim, thank you very much. PNC Bank, Premier Consulting, Product Ability, a division of the Resource Center. They'll be here soon. Quick Solutions, John, thank you. Rogers Land Surveying, the Safety Compliance, the Saxton Coker and Associates, Schaffner Knight Minna and Company, UBS, and WCA Hospital. It's those folks, coupled with the Chautauqua Region Community Foundation. Randy, here we go. Phillips Lytle, make sure you say hello to them to make sure you drop these things off. The County of Chautauqua Industrial Development Agency, the Legend Group, and, of course, the Chautauqua Abstract Company, John Ortendahl. John, thank you very much. Those are the folks that make this all possible. They make sure that we have these ongoing events, and most important, for the lawyers, they get continuing legal education credit. I'm thrilled about all of the quality speakers we're going to have today, and I'm thrilled that you all could join us. And with that, I'm going to turn the program over to Randy, and folks, you can have a seat and come join us for the first presentation. Thank you, guys.
Morning, everyone. I'm Randy Sweeney, Executive Director of the Chautauqua Region Community Foundation. I'll be introducing our speakers at each of our sessions today. As Greg had indicated, we're going to begin with Craig Bucki. Our topic for this first session is records, retention, practice, and legal advice. Mr. Bucki is a partner at Phillips Lytle in Buffalo. He's a graduate of Yale University and Columbia University School of Law. Mr. Bucki focuses his practice on litigation involving state and municipal government, public authorities, and other quasi-governmental entities. Mr. Bucki.
Can everyone hear me? Good. Excellent. Good morning. First of all, thank you so much for having me this morning. I got a call from Greg Peterson in the first week of January. I had become a partner at Phillips Lytle on January 1st. And that first week of January, he called me up and he said, first of all, Craig, I want to call you to say congratulations on becoming a partner. We're so happy to welcome you into the partnership, really excited about having you be a partner. And by the way, would you be willing to speak on ethics at my CLE that I'm going to be hosting at the Jackson Center on May 5th? And so Greg certainly has a way of encouraging people to help him out when he needs some help. And I was more than happy to oblige. And in particular, I am a member of the Ethics Committee of the Erie County Bar Association, and Greg said that there was particularly a need, and this is true, I think, throughout the state. There's particularly a need for the attorneys to be able to get some ethics credits for CLE. All of you need to do 4 ethics credits if you're experienced attorneys over the course of your 2-year registration period. And for whatever reason, there aren't all that many offerings in the ethics realm for CLE. And so I'm happy to do this for the Jamestown Bar, for the bar throughout Chautauqua County, to be able to talk a little bit about ethics, and hopefully you'll learn something that you'll be able to use in the course of your own practices. And out of the many, many topics that we could discuss, I think the number one question that we get at the Ethics Committee of the Erie County Bar Association would have to do with billing and would have to do with record keeping, because these are the kinds of things that sole practitioners need to be very well versed about how to do. Small law firms with a few attorneys, not of a size of 50 or 100 or even more, the attorneys themselves are the ones keeping the records, and the attorneys themselves are the ones handling billing matters. You know, this isn't New York City where you have a law firm that has 1,000 lawyers in it and someone is delegated to worry about all of that. A lot of you are dealing with these kinds of issues every day. And so I thought it would be most helpful if we would have a discussion this morning about the kinds of things that you should be remembering in your billing practices and in your record-keeping practices as attorneys. And so if you look at the materials that I've put forth, I'm going to go basically in the order that the materials go, but I'm not simply going to regurgitate what the materials say. And in particular, at various strategic parts of the materials, I'm going to put forth some hypotheticals. And these are real-world hypotheticals that have been evaluated by the State Bar Association Ethics Committee, and concerning which the Ethics Committee has put forth opinions over the past 5 years, ever since the rules of professional conduct replaced the old disciplinary rules and ethics considerations back in 2009. So first I'd like to talk about billing and then we're going to talk about record keeping. So with respect to billing, how the clients should be charged, the most important thing to remember about billing is that the fee cannot be excessive. It needs to be a reasonable fee, and the standard of reasonableness is an objective standard of reasonableness. So under the Rules of Professional Conduct, Rule 1.5a, it says that the fee charged to a client cannot be excessive. And excessive is defined as excessive in the mind of a reasonable lawyer pursuant to his or her definite and firm conviction upon a review of the relevant facts. And the rule goes on to state a whole variety of different criteria that should be examined in determining whether a fee is excessive. And those different criteria are set forth in the materials, and there are 8 of them, such as how much time is going to be necessary, what kind of work is going to need to be done, what kind of fee would ordinarily be charged in the relevant community where you are. Obviously, a different fee is going to be charged in New York City versus Buffalo versus Jamestown. I had a case last year where an attorney's fee application was made to the court by an adversary, and the partner in New York City at one of the large law firms was charging over $700 an hour for his time. If only all of us could be so lucky. And that flies in New York City. It wouldn't fly in Chautauqua County, and it wouldn't fly in Buffalo or in a lot of other parts of the state. So really, reasonableness is a function of a variety of factors, and where you're located is certainly one of those factors. Earlier this year, March 25th, 2015, the State Bar Association put forth an advisory opinion. And the question was whether a lawyer could charge a convenience fee to someone who was a client who wanted to pay by credit card. And now I'd like to go through a couple different examples from the ethics opinions, and this is the first one I'd like to go through, because some of you may have clients who would like to pay by credit card, but oftentimes what the credit card companies do is they charge an additional fee, 2.5%, 3%, whatever it may be, that the credit card company collects and that is taken out of what is paid. And so the lawyer asked, well, can I charge extra to people who want to pay my bill via credit card for the sake of convenience? And the lawyer said further, even if I charge extra, there's still going to be a convenience fee on top of that. So what I would like to do is charge even a little more than the convenience fee so that I can be making sure that I don't get hurt by the fact that I'm allowing this customer to pay by credit card. And so the ethics committee thought about it, and on one hand, there's the argument, well, this attorney should be able to recoup the full value of his services, and then on the other side, you have the argument that under the rules, there isn't supposed to be any so-called fraudulent billing. That's in Rule 1.5D3, and so to impose an upcharge on a client simply for paying by credit card almost feels somehow unfair. So under the circumstances, just to liven things up at 8:45 on a Tuesday morning, by a show of hands, how many people here would think that the convenience fee, that additional upcharge to be imposed by the lawyer, would be ethical and appropriate? And how many of you would think not? Lo and behold, the State Bar said yes, it was appropriate. And what the State Bar said, and I'm quoting from their opinion, a lawyer may, as an administrative convenience, charge a client a nominal amount over the actual processing fee imposed on the lawyer by the credit card company, so long as, number one, the client receives disclosure of the upcharge and consents before it's imposed. So if you give full disclosure and the client says, I'm okay with that, I still want to pay by credit card, that's a necessary condition. Number two, the upcharge has to be nominal. So you can't charge an exorbitant amount beyond what would ordinarily be charged. It has to be a nominal fee. And third, the total amount of the fee, the attorney's fee plus the ARP charge, needs to be reasonable under the circumstances. So if you have any clients who want to pay by credit card, and if you want to capture that nominal fee, it's okay under those circumstances, and that is what the State Bar has told us as of just about 2 months ago. Another example, some of you may have corporate clients, family businesses, small companies in Chautauqua County, Cattaraugus County, elsewhere. And the question was presented to the State Bar about 3 years ago as to whether it would be ethical and appropriate for the attorney, in lieu of accepting an attorney's fee, simply being paid money, whether the attorney could take an equity position in the company as payment for the services rendered to the company. And this is something that has happened particularly in the bigger cities among some of the more entrepreneurial lawyers who tend to think about strategic ways to get paid. It's something that others have done, but there's always been kind of a taboo about whether that is something that can be done. And the State Bar Association 3 years ago said, yes, it is something you can do, but if it's something that you're planning on doing, then what you need to do is follow Rule 1.8, which concerns business transactions that an attorney makes with his or her client. And so what Rule 1.8 says is that a lawyer can enter into a business relationship with a client as long as, number one, the transaction is fair and reasonable. Number two, all the terms have to be disclosed. And again, disclosure is something that you see a lot in the course of the rules. Disclosure remedies a lot of flaws and turns a lot of things that would otherwise be unethical into things that would be perfectly ethical and appropriate. Not always the case, but in many cases that's true. So fair and reasonable, full disclosure, it needs to be in writing, it needs to be fully understood by the client, so it can't just be a situation where you put a piece of paper in front of the client and the client doesn't read it, doesn't take time to understand it. The client needs to make sure that he or she understands it, and the client needs to be told in writing that you should confer with independent counsel before you enter into this relationship, and the client needs to have a reasonable opportunity to seek out that independent counsel. So just relying on your word that it's a good thing for you as an attorney to be paid by getting an equity position in the client, that isn't good enough. The person needs to have an opportunity to seek out another attorney's advice on the matter as well. And then the client needs to give consent, obviously, in writing as well. And so under those circumstances, then yes, it would be appropriate if you're doing a deal or some kind of corporate representation to be paid by virtue of taking an equity position in your client. Opinion number 910 from March of 2012. And this may be a situation that you have with some of your clients, I hope with not many, but this is the situation of the client who doesn't pay your bill. Collection is a very difficult thing for attorneys who are practicing on their own or who are practicing in small firms. You'd like to think that all of your clients are going to pay, and I'm sure most of them do, but on occasion, you have the client who doesn't pay you. And so the Bar Association was presented with a hypothetical that there was an attorney somewhere in the state who had a client who had not paid his or her bill, and then that client came back to the attorney and said, I'd like you to do some more work for me. And the attorney didn't want to turn the client away, but at the same time didn't want to be stuck with doing more free legal work for somebody who had every capacity to pay. And so the attorney's normal rate was $245 per hour. And the attorney had the idea, you know what, I'll do the work for you, client, but because you owe me money from the past, I'm going to charge you $735 per hour instead of $245 per hour. And so the attorney's view was the fact that this client hadn't paid justified skyrocketing the rate to a very large number. And so how many of you would think that that would be okay? None of you. How many of you think it's not okay to do that? That's pretty much everybody. And the State Bar Association agrees with you that that is not the appropriate thing to do. And the State Bar said if you have a problem with a client who isn't paying your bill, you have remedies available to you. So for instance, you can go to the client and say, look, you owe me this money. Before I take on any more legal work for you, I would like you to sign a confession of judgment in which you agree that a judgment will be entered against you for the amount that you owe me. Or, in the alternative, the attorney could take a security interest or put a lien on some property that's owned by the client as a means of hopefully getting paid in the future. Those are just two examples that were provided by the Ethics Committee, but what you cannot do is charge a fee that is so exorbitant and so unreasonable, even if the purpose of charging that fee is to make up for the fact that there were attorney's fees that were owed in the past. Going back to the outline, Rule 1.5D1, some of you have criminal clients. It's very important to remember, no contingent fees may be charged to your criminal clients. So if somebody is charged with a misdemeanor, a felony, you cannot charge based upon whether you'll be successful in terms of obtaining a certain disposition. Now, an enterprising attorney went to the State Bar Association Ethics Committee in 2011 and asked, well, what about vehicle and traffic matters, like speeding tickets or failure to yield the right of way, where it's a violation but not a misdemeanor and not a felony? Can I charge a contingent fee for that? So if I get you off for speeding, then you get to pay me, but if I don't get you off, then you don't have to pay me anything. What would be your thoughts? Who thinks that a contingent fee for a speeding ticket would be okay? Who says no? The State Bar said that yes, it would be okay for the contingent fee to be charged because speeding tickets, failure to yield the right of way, those are violations. And under the way that the rule is written, it says that contingent fees cannot be charged for criminal matters, and a violation is not criminal. Only misdemeanors and felonies are criminal. So if any of you in your practices think that it might be a good business model to charge a contingent fee when you handle a speeding ticket in town court or village court, State Bar Association says it's perfectly all right. But what they did say is that if you're going to have that, you need to have a written agreement, full disclosure, consent by the client. Everything needs to be presented up front before the client enters into that type of arrangement. Non-refundable retainers. Don't do them. They're not permitted. It is possible, when you look at Rule 1.5D4, that you can charge a reasonable minimum, whereby you say, this is what I expect the work is going to cost, and so this is the minimum that I'm going to charge you. But you cannot have a situation where you take in a retainer, you do a certain amount of work, it turns out that in order to get the job done, you don't need to spend the entire retainer, and then you say, well, I'm just keeping the retainer. That is not permitted under any circumstance. And so if you want to have a minimum amount that you plan on charging, there needs to be a reasonable minimum fee clause that defines in plain language and sets forth the circumstances under which the fee may be incurred and how it is supposed to be calculated. I'd like to spend a couple minutes on domestic relations matters with respect to billing. I'm sure a lot of you, if you have general practices, handle at least some divorce cases every now and then. And there are very particular criteria that you need to keep in mind with respect to those divorce cases. The first thing that you should remember, no contingent fees in domestic relations matters. So you can't have a contingency based upon whether you obtain the divorce. You can't have a contingency based upon whether there would be child custody awarded to the spouse who you're representing. You cannot have a contingent fee which is based upon how much maintenance or support that your client is going to receive. This has been the law under the rules of professional conduct, and it was the law in New York even before the rules of professional conduct came into being. So that's number one. On balance, no contingent fees. Number two, you need to have a written retainer agreement. And this makes a lot of sense because especially in domestic relations matters, you are dealing with very emotionally charged situations. People are upset over the course of, over the fact